Good morning, everyone. My name is Deb Fewster. Thanks for joining us. I'm the Director of Policy and Advocacy at the Victorian Council of Social Service, known to many of you by the acronym VCOSS. It's great to have you with us today. I'd like to start by acknowledging the traditional owners of the land where I am today. I'm at the VCOSS office in Exhibition Street, so I'm on Wurundjeri land, and I'd like to pay my respects to elders and ancestors, and really to make sure I'm acknowledging any Aboriginal people who are in our virtual room today here for this event. So warm welcome to everyone, and always appreciative of being on Aboriginal land, always was, always will be. Just a quick note about accessibility today. We take this really seriously at VCOSS. If you require captioning, you can access it via the link that's been posted in the Zoom chat. So again, great to see you in this virtual room today. I think we've had more than 300 people register for this event. These are always very popular events. And today is quite significant, or this week is quite significant, because we're celebrating the anniversary of the new rental rules coming into effect in Victoria. So more on that later today. But first of all, I just wanted to give you, step through a rundown of what to expect in this session today. I'm going to begin by detailing the current status of renters' rights in Victoria, including how we got here. So just a bit of a quick kind of history, given that we are in this anniversary week this year, and it's a very busy and complex reform space. Then it's time for the main attraction, our feature presentation by our wonderful colleague from Tenants Victoria. Tenants Victoria's lead community education lawyer, Ben Cording, who I think has like icon status with these events and in the sector. As you know, Ben is an absolute encyclopedia and a fantastic presenter. So I know that we're all in good hands today. And Ben is the reason why many of you have registered for this event today. Then it will be time for you to ask questions. We've got plenty of time for that today. Anything that you'd like to know, anything that you'd like to clarify, nothing is off limits in terms of questions about renters' rights. If we can't answer the question today, because we just need to follow up with a bit more kind of technical detail, we might take that question on notice and come back to you. As I said, we've got plenty of time for questions today, but if we happen to run out of time, we will kind of take a look at questions that have been kind of posted, and we'll do our best to kind of come back to people and answer those questions and publish those answers with everyone who's attended the event today and registered with the event today. After the Q&A section, which is kind of, again, a big chunk of time today, I will give you a bit of a sneak peek of a forthcoming VCOSS report called Renting in Victoria. That is about or comprises insights from community sector workers. Many of you have had input and shared insights into that report. It is a deep dive into the reality of renting, and it does come from, it is fueled by the voices and lived and living experience of workers in the sector who are providing direct and indirect support to renters. But more on that later today, this morning. And last, I just wanted to flag kind of the next steps in this reform space as well. So a little bit of history, and I'm going to whip through this really quickly so we can get on to Ben's presentation. But I think, you know, it's really always important to kind of ground this conversation, like what's come before, as well as looking ahead to what's next. So we're going to flash back here, as you can see, to 1997. I remember Elton John being at the top of the charts with Candle in the Wind, and the Kennett government passed the Residential Tenancies Act, which was around really merging and modernising different existing acts. Decades of advocacy for better rights for renters then followed, including a very persistent campaign for the introduction of strong minimum standards. We're going to flash forward now to 2017, where we see Labor promise minimum standards in the lead up to the Northcote by-election. So that was a really significant moment for renters and for our sector, really kind of seeing that advocacy start to kind of really have some strong traction. That's when we then see, I guess, advocacy kick up another gear. The community sector then kind of launches a coordinated campaign called Make Renting Fair to keep pressure on the Victorian government. And together, and this really speaks to, I guess, the power of working together, of collaboration, of collaborative systemic advocacy. But together, we lobbied the upper house crossbenchers to support those rental reforms. It's a really significant moment for our sector and for renters. Then we kind of move into September 2018. We see reforms pass the Victorian Upper House, and these reforms include more than 130 changes to the Act. We then see later that year Labor winning the 2018 election, and then in March 29th, 2019, the new Act taking effect, which is kind of the birth of the anniversary that we're kind of celebrating today. Still lots more kind of sector work and advocacy undertaken after that, because as we know, devil is in the detail. So a lot of work on the regulations that underpin those new rights are written. And then COVID happens, requiring a range of kind of unplanned but kind of welcome emergency measures during that period. And again, an example of community sector organisations working really closely, collaboratively together, to be a united voice to government and working, in a really excellent way with government to ensure kind of really excellent protections for renters during kind of this unprecedented global pandemic. Then we've kind of settled into, I don't know what we call it, a new normal of some sort with COVID, living with COVID. But what that enables us to do is kind of then, lift our gaze again and finalise those regulations and have them implemented. So now we turn our minds to what's next, because it's always kind of a very dynamic space. And we'll kind of talk about that at the tail end of our event today. So that's how we got here. Let's talk now about the existing protections that renters have. Let's answer any questions that you have following Ben's presentation. But with that background and with no further ado, I wish to introduce Ben Cording. As I said, Ben is the lead community education lawyer at Tenants Victoria. He's going to talk us through, everything that we ever wanted to know about the current laws and regulations. But in particular, we're going to hear a bit today about the rent increase framework and kind of key points about that. At any time, you can submit a question through the Q&A box at the bottom of the Zoom window. So just look out for that. Please enter your questions. We're really here to kind of be responsive to your needs so that we can help renters know their rights and help them to assert their rights in this really fraught rental market. We have 90 minutes allocated for this session. We might not need it all. And if that's the case, we'll kind of give you back some time in your diaries at the tail end of this event. But over to you, Ben. Take it away. Thank you.
Thanks so much, Deb, and it's really helpful to have that context as well, just in terms of how things have evolved. So hello, I'm Ben, lawyer, not too scary, hopefully. Just quick 2 seconds about myself. I'm a dad, I've got 3 kids. We're a neuro-spicy family. Some people use that word. Quite helpful because life is spicy. I find that it's difficult to believe that butter now costs somewhere between $7 to $8 and a block of cheese is $10. Sometimes at the end of the week, I've got like 20 bucks left. Many of you, the community workers, will probably know what that feels like as well. My parents are boomers, so I have a sense of security that many other people don't. So it's a really brutal time for renting, but at the same time, there's a lot of opportunity. And what's so important about the work that many of you do is that you're hearing the stories that go to government that inform how these changes happen. So without further ado, I'll share my screen. Hopefully you can see that. And yeah, look, there really are, any question is fine. I mean, sometimes I might give you more of a political view than anything else, not necessarily always formally endorsed by Tenants Victoria, but I tell you what you think. And yeah, look, it looks like Sim City. We thought that the city would expand, and now we're looking at, is the city going to build up? Many of you may have or may not have seen there's been announcements towards granny flats now being allowed, and that's a really interesting strategy that the government's adopted. I think you can have up to a property of about 60 square metres. There are some tests about the amount of vacant land, but it is a really good option for some complex families or for some complex situations, and it's probably a lot cheaper to get a portable granny flat than actually a full house build. Anyway, anyway, I'll leave that to the side, but if you're not aware, check that one out. I'm on the lands of the Yalukit Willem people. I want to pay my acknowledgement, respects to elders past, present, and most importantly emerging, in the celebration of First Nations people, and a commitment to closing the gap and working to justice with First Nations persons. Yeah. All right, so these are not a substitute for legal advice. We're required to put this in by our insurer. The most important thing out of this session is that you can call us. So regardless of your community professional background, as long as you're from an organisation and that you're helping a renter, you can call through to us and say, look, I'm an organisation seeking advice, and it's going to be a lot quicker. The reality is the biggest complaint that we get is that people can't get onto us. VCAT does about 50,000 hearings a year, so that's the Victorian Civil Administrative Tribunal where most matters are heard. So you can kind of, jump the queue and get in a little bit quicker, and you can do that independently of yourself and relay information, or you can have your client there with you. If it is a family violence matter or a particularly complex matter, we might need to get the names of parties just for our records. Now, if you haven't heard of Tenants Victoria before, we are a free community legal centre, but we're also a peak body for renters. So we do the legal work, but we also do a lot of reform work, and that's why the work that VCOSS does is so important. And you can see that journey is a constant journey. One of the things that's in the future is what's called the housing statement, which was announced in September, and they're looking at a number of reforms, which I'll talk through throughout the presentation fairly quickly. Might include a bond carryover scheme, because at the moment people kind of need two bonds. One gets locked up in a bond dispute because they think you've dirtied the walls, and then you've got to wait a couple of months, and you're like, well, I've got to get into the new property. So you need two bonds, which is a lot of money for some people, for most people. So anyway, we started in 1974 from a bunch of, perturbed renters and going, well, it's not good enough. And I'm only part of a very long journey and heritage and stand on the shoulders of a lot of great work from many other people. So we'll just touch on some of the reforms. So you may or may not be aware of them. We'll look at some practical tips for renters and then just about accessing help. So hopefully it'll be fairly quick. I do apologize if I talk quickly. I want to try and get through this so you can get to your questions. So one of the major changes that happened is that when a landlord wants to kick someone out, they've got to start with this notice to vacate. That's the first thing they've got to send. It's illegal for a landlord, or now they're called a rental provider. It's the same thing. It's the idea that it's a service. They're not landlords. They're, service providers of an essential service. They can't kick you out for no reason. Many other states and territories around the country have followed suit. Some are in the process of following, which means that it's great, because one of the major things that we see is that renters are afraid of using their rights because the landlord can just turn around and say, well, get stuff, kick you out. Now, you can always challenge it if it's been retaliatory. So we don't have a no reason notice. The closest thing we have is what's called an end of initial fixed term agreement. So that means it only applies to the first fixed term. So if you get through that first 12 months and they don't give you the notice to vacate at least 90 days before the end of that fixed term ending, then you're fine. They have to try and kick you out for a reason. The most common reasons that we're seeing landlords try to kick people out at the moment are that they're selling, the landlord wants to move in, and occasionally sometimes they're using it for a business purpose or otherwise, but they tend to be the main ones. The other main one that we see is repairs or renovation. Now, one of the other changes is that when they give this notice to vacate, they actually need to provide certain documents. So in the case of repairs and renovations, they've got to have a tradesperson say how long the work's going to be done. There's got to be a quote. They have to have the building permits already approved if they're going to do some major works. And they need to show that the works can't be done while the renter's living there. So there's quite a number of tests involved. And the other thing that happened in the eviction space is what's called the introduction of the reasonable and proportionate test. So that means even if the landlord can prove, yeah, I am really going to try and do these renovations, or yeah, I really do want to move in, VCAT can actually still say, well, what's the impact on both parties? So we've had some VCAT decisions, so that's sort of like a court, but it's much more relaxed. I tell people it's a little bit like Judge Judy sometimes. So most people will represent themselves. And the tribunal's going, well, I've got a family of 4 over here, and I've got a landlord that says he can't live with his family anymore. Might be some mental health, could be legit, could be a little bit questionable. But pretty much the tribunal went, well, there's 4 people versus 1. I'm not going to give you their property back at the moment. So they might have to try again later. But there is a balancing activity that's never happened before. And it also means, and particularly for many of you community professionals, it means that knowing our clients has become so much more important. Because it used to be like going, well, if the landlord can prove they're selling, I don't really care about what's going on for the renters. It's not something I have to consider or I should consider. Whereas now it is. Now it is. And so that's really important to know. How's our client? Oh, they've got cancer. Okay, well, that's going to be really significant. Oh, they've got diabetes and they need to store their insulin in the fridge. That's going to be really significant. So many of you community professionals out there will have really much better knowledge than what the lawyers will. Much better, maybe time. You've probably got time pressures on you as well. But my important point is that we're dealing with human beings, we're dealing with lives. And in fact, now the law is a little bit more understanding of that. There's no guarantee, but it means that we need to understand bail, parole, mental health, child protection. In fact, there's a huge issue for a lot of people on waiting list of going, well, child protection says I can't get the property unless I've got a bigger house, and then I can't get a bigger house unless I've actually got child protection to say I've got the kids. And so there's this circular problem of moving up and down the list. The departments need to talk to each other. So there are all sorts of areas which you as community professionals will probably have intimate knowledge, and sometimes the lawyers, tenancy specialists like myself, may not even have any idea. We've seen the NDIS shift a little bit in terms of about allowing people to be funded if they live in a sort of like a cooperative or supportive housework where you've got other housemates that will sort of help out. And so the NDIS may go, well, maybe I will pay rent in that space. It's more efficient. So there's a responsiveness that we need to encourage and grow. So there's also now the introduction of what's called a threat and intimidation notice. This was one that many community housing providers celebrated. You can also challenge this if it's being given in retaliation. So your client can arc up. In fact, there's a number of cases where the client said, I've had enough of you, that sort of stuff. And the tribunal said that's not really a threat and intimidation. It's got to be a degree of malice, or that they're really going to carry through with that threat. So if you see something like that, give us a call and we can have a chat about what's going on. But the main thing is that a landlord or a rental provider, real estate agent, they can never evict someone other than following these processes. So if someone just gets locked out, you get a landlord going, I don't care about the law, I'm just going to lock you out. That's an illegal eviction. So you can get the person back in, or you could get quite a large amount of compensation for it. So that's an option. One of the other shifts that we've seen that's been introduced is instead of evicting someone, giving what's called a compliance order. So you might have someone that has a major altercation, had some fighting. The tribunal said, look, I'm pretty satisfied this has happened, and it might happen again, but actually the detriment for this person of being kicked out is really big. So maybe what we should do is actually make a compliance order, and that's kind of like a warning bell, saying that you now have this order saying you can't commit abuse or engage with that person, whatever it might be, and if you do, then the rental provider can give you a notice to vacate for 14 days. And so we've got the opportunity now, again, knowing the client, knowing the impact of the eviction, of potentially stopping it and keeping the home, and the person goes, right, I know I need to keep my nose clean for a while. Ideally in compliance orders, we always want them to be time limited, but in fact they might not be. And so it's really important if your client's facing things like hoarding. Hoarding is one where we see the law and clinical health best practice are not talking to each other very well. We want to have measured and achievable results, but we need to balance, the danger to the neighbours. So it's all a balancing activity. We saw in the new laws that people can have pets. One of the major issues that's emerged is that there's no protection in application processes to say, I want to remain silent about whether I have a pet. Ethically, it's hard for lawyers to say, look, ship your dog off to mum and dad, get the house, and then say you're getting a dog. So that's a little bit complicated, but we know that if people say, yes, I have a dog, you don't always find out why you don't get your rental property. They don't come back and say, hey, 300 people, this is why you didn't get it, this is why you didn't get it, and this is why you didn't get it. It doesn't work like that, which makes it really hard for people. And so we are seeing cost of living and a lot of surrendering of animals. So it's a celebration. A lot of people require and benefit immensely from therapeutic animals, and we want to make sure that they are protected as much as possible. So there are protections for assistance dogs specifically, but I think that there's a broader equal opportunity discrimination case. We also saw that direct discrimination got built really strongly into the Act. It's always been there with accommodation. There's in fact only been one case about a transgender woman who asked for the correct pronouns to be used, and there were some arguments, and it unfortunately wasn't as successful for a number of reasons, but we know that discrimination is going on. In fact, one of the things I'll pop or hopefully send out through Deb as well is that we're doing a research project with Melbourne University to try and identify racial rental discrimination, because there are many people who are prejudiced, and even though it's unlawful, you might come out to a housing inspection and they give forms to everyone else, and you might be the only person of colour, and they're not going to form and go, WTF to that? And so unless people share those stories, in fact, the Victorian Human Rights and Equal Opportunity Commission has recognised that a lot of people don't want to make complaint because they're like, well, I've got to go back to the agent and that's going to be really hard for me to get the property. That's going to be sort of a victimisation. And so they recognise that maybe just telling the story so people know how this discrimination is happening is so important because it's systemically structured. If you don't get a house, everything else becomes disadvantaged as well. And we see the same thing with gender inequality and family violence is that there's structural inequality. We saw a lot of people during COVID draw down massively on their superannuation. One of the things I didn't know, which a financial advisor told me recently, is that if you go bankrupt, your superannuation is actually still protected. So, maybe financial advisors. We actually have now 2 financial advisors at our office, which you can, again, call and try and have a chat. Tom and Jacinta are our financial advisors if you want to have a chat there. So the eviction process, which is where, many of your clients will present as a point of stress, and we'll talk a little bit about arrears specifically, it starts like this. You get a form, a notice to vacate. It's got to be by hand, like literally given to you, not just slipped in the post box or under the door. It's got to be given via registered post, or it's got to be given to you electronically. But if you get it electronically, you have to consent explicitly. It can't just be because you're in the habit of emailing or SMSing back and forth. For some of your clients, that's fine. I hate checking my personal emails. I hate getting my registration notice to vacate, my car registration in the email because I almost missed it last year. The only reason I wasn't driving unregistered is because Google picked it up, my emails, and said, hey, you should pay this tomorrow. I'm like, Dad, I need some money because I can't afford it. So, privilege. So once the renter gets this notice to vacate, you don't have to leave by the termination date. So in the notice, it'll say you are to be out by the 1st of June. You don't have to be out by the 1st of June. What happens then is that it forces the rental provider to apply to VCAT. So the tenancy just continues on until the tribunal says, yes, it's over. And even then, the police attend to execute a warrant. So it's not criminal in nature. It's just a piece of paper that authorises the police for the eviction to take place. So when the rental provider applies to VCAT, the renter gets told, hey, there's a hearing. You should probably go. Most of the hearings at the moment are being done over the phone still, but we are slowly moving back to in-person hearings. Just as a matter of supporting our clients, a lot of people feel much safer attending on the phone. They don't lose the work because sometimes you get adjourned and go, great, I lost a day's worth of work or my leave, and now I've got adjourned, I've got to do it again. So appearing on the phone is a really useful thing. It is harder to present evidence. It's harder in complex matters. And we'll talk a little bit about that in rent arrears as context. VCAT. So when you get to VCAT, they'll look at, was it given to you the right way? That's called service. They'll look at why was the notice given. So is it rent arrears? Is it the landlord selling? They look at the evidence to see that it's there. They do the reasonable proportionate test and any defences. So the reason that the lawyers particularly look at the number of days and we count the postage time and we look at what exactly is in the statement is because if they stuff any of that stuff up in the notice to vacate, it's like Willy Wonka's golden ticket. You cannot get into the chocolate factory. No chocolate for you. So if they stuff up the ticket, VCAT has to dismiss it. And that's why the notice to vacate and understanding what the requirements are legally are so important. You don't have to understand that. But if you smell something funny, you're like, oh, what's going on? Give us a call. Just give us a call and we'll try and chat through. So VCAT really has 2 options. It can say, yep, everything's satisfied. I think the impact between the parties on balance, the landlord should get their property back. They make the possession order. So you'll never leave a hearing with an order saying you can't go back to your property. It will say, in some cases, renters might go to the hearing, the possession order is made, and they can get up to an extra 30 days. In other situations, you might not get it, but it's pretty common with hardship at the moment. If you've been looking around, it's really important that renters look around for that hardship to be shown, and you can get it up to an extra 30 days. And if they stuff anything up or they think it's not reasonable and proportionate, they have to dismiss the landlord's application to get the property back. So with rent arrears, you've got to owe more than 14 days worth of rent arrears. The main thing people know, you stay in the property. They ask you to leave by the 1st of June. You're staying there the 2nd, 3rd. The rental provider applies. You go to VCAT. They want to know, how'd you fall into rent arrears or why? Can you pay your normal rent? And if you can pay your normal rent, on top of it, how much extra can you pay over a reasonable period of time? So that becomes a super important question in terms of financial advice. VCAT can adjourn it for someone to go off and get financial counselling, but unfortunately, there's no prescribed agencies where they can mandate and say, hey, you've got to do it. So give us a call if you're trying to get access to that. And ultimately, they'll make that decision about, yes, you can pay it off over this time. If you're in community housing or social housing, your chances of getting a payment plan can be really, really quite low. There are policies about how that works. In private housing, we're seeing a lot more landlord stress coming into operation going, I'm going to default on my mortgage. Should I give a payment plan? And again, it's a real balancing activity, and it can be quite a tricky thing. One of the major changes that has happened with the rent arrears framework is that if someone gets they get more than 4 notices to vacate, so they get up to their 5th notice to vacate in a 12-month period, and all of them are valid, you can't get a payment plan. Reasonable and proportionate test still applies, but you can't get a payment plan, and that's really, really difficult. That 12 months resets every anniversary since the tenancy begun. So it doesn't matter if you signed a new fixed term agreement, it just restarts. If you started your agreement on the 1st of March, next year on the 1st of March, it will be a new 12 months, and then you might be back to what we call strikes. They're not called strikes in the law, but so that's just a bit about the rent arrears framework. The main thing is to find out where'd the money go, and can they pay their normal rent? Can they catch up? And for a lot of people, even though in social housing we see 30% being the acceptable benchmark, we're seeing people paying 60, 70% of their income on rent. Rent increases have just been unprecedented, really. Some areas about 30% over the last 3 years. An important point with rent increases when we come to them is that there's actually been a decision that's been published to say a fixed price increment, like going from 1,500 up to 1,700, is not a method. The law requires a method to be specified, and it's got to be calculable. And that idea of just jumping up and saying, I just picked a number, is actually not considered to be a method. That's a VCAT decision, so it's not binding, but it's pretty good indication. We'll jump into rent increases shortly. I'm just aware of time. All right, so when you start a rental agreement, we've seen that there's a ban on range advertising, so you've got to advertise for a fixed price. Now, there's a ban on rental bidding from agents soliciting offers, and we're hoping the housing statement, they'll make some reforms to close this gap, because most renters are the ones making the offer in a market the way it is, with a vacancy rate that I think last time I saw was 1.08%, which in a healthy economy should be about 3 to 4% of, out of every 100 houses, there should be that many on the market for lease. We're running into some issues. So that will hopefully close and stop landlords from accepting bids, or from renters making those bids to stop that elevation and passive bidding against each other. So mandatory disclosure requirements, there's quite a lot of these. Asbestos, if there's homicides, if there's been drug manufacturing, if there's been mold reported in the property in the last 3 years. There are prohibited questions. So if you've had a bun fight, like a legal issue with your landlord previously, they can't ask you about it. They also can't ask for any of your bank transaction statements. They just want a summary of finance, which is again a little bit helpful for renters. And they also can't ask about any protected attribute. I might be a male, female, non-binary, however I choose to identify. It don't matter. I need a house, and you shouldn't be asking me that. And yet we still see many of these platforms and applications asking those sort of questions. Same as number of children, potentially. If they do ask for a characteristic, they can ask for it, but they need to explain why they need that information. We see minimum standards being introduced. You can see all of them on our website. Unfortunately, air conditioning is not there, nor is insulation. There are some probably political background issues to both of those issues. Equal opportunity has been incorporated. So it's really about discrimination. There's direct discrimination, indirect discrimination. Direct discrimination would be like, oh, you're from Turkey. Oh, I don't want anyone from Turkey. I want an Australian, that sort of thing. Indirect might be, I only want someone that can speak fluent English. And so you've got that idea that it sets an unnecessary or unjustifiable requirement that has the effect of prejudicing other people. So copies of keys now must be given for each person. So if you've got 10 people on the agreement, that's 10 sets of keys to access all the properties. We also saw that the SDA, the Specialist Disability Accommodation, has been brought into the Residential Tenancy Act. That was a major move for the disability space, and probably part of a reflection of the movement with the NDIS a few years after the NDIS was introduced. And so that's really, really important, because a lot of people in SDAs, Mental Health Community Legal Centre and Villa Manta, who's a specialist community legal centre for persons with disability, indicated that there are some people that are paying 90, 95%, and they're entrapped in those SDAs because they can't afford to get out because they've got nothing to save. So if anyone contacts you and you think they're an SDA, absolutely give us a call, give Milvanta a call. Those persons should really be treated with a high level of priority. And many of you will potentially have clients that are in SDAs, or also there are what are called SRSs, which are supported residential services. They have their own legislation, but it's very similar to the Residential Tenancy Act. During a rental agreement, there's main thing, landlords need to make sure the house is in good repair and now also a suitable condition for occupation to live in. It's not a lot of case law actually on that latter part, but absolutely when you rent a property, the landlord can't say, oh, but it was like that when you signed, when you moved in, we don't have to fix it. If it's there, it's got to be in good working order, it's got to be safe, and it's always the landlord's duty. They can't delegate that to you. They can't withhold a consent from having a pet. So if you do have a dog, they have to justify why you can't have the dog. And pretty much all the cases, bar one that I know of, have been successful in people being able to have pets, noting that issue of when they're applying, and the passive prejudice for people that have got pets. Modifications now as well. You can make modifications for security, so you don't need an intervention order. If you've got someone that's stalking you, or for whatever reason you're concerned about getting the IVO, you can still look at putting up a CCTV system, one that plugs in. You don't really even need consent for. If you're going to get a hardwired system, the law is that you can't unreasonably withhold consent. For many of you with clients that are doing it rough, because God knows utilities are extremely expensive at the moment, is that you can do improvements for thermal comfort. So again, some where you need consent, some where you don't need consent. But if you have a dispute and you think they're withholding consent where they shouldn't, you can apply. VCAT has to hear it within 5 business days. So it's a pretty quick turnaround. Again, that's consent, not necessarily paying for. If you do any modifications, you do have to restore the property back the way it was before you moved in, unless parties agree otherwise. Now, during a tenancy as well, they've got to do gas and electrical checks for safety every 2 years. So even if the tenancy is just continuing, they still need to update a check and make sure that the house is safe. So it's a wonderful thing now. When you rent a house, there's got to be a safety switch, RCD, residual current device, so your kid can't shove a knife in the electrical point and zap themselves, because death is bad for your health. So appliance replacements, when they replace an appliance, they've got to be energy efficient. The standards are relatively low, but at least it's a starting point. And we also have a framework now for when they come in for photos and videos. That's for advertising the property. If it's for a sales campaign and the like, there is a framework where the renter can object. If you're a person affected by family violence, you can say, look, I'm a protected person. I've got an intervention order. I only want to do it by appointment. That's completely understandable. And again, there's a bit of a negotiation. If they're doing inspections now, unfortunately, open inspections are permitted. They must give proper notice, but the renter's got to be either paid $30 or half a day's rent, whichever is greater. So you get something. There's nothing about saying when that payment needs to be made, but better something than nothing at this point. And then rent increases for most agreements, it's going to be once every 12 months. So I'll touch on rent increases, and I'm sure that'll come up as a question. It is certainly affecting a lot of cohorts, in particular older persons, where the pension's just not cutting it. They've been on a cheap wicket, and rent increases is a market-based test. All right, so ending your agreement. When you want to end your agreement normally, you've got to give 28 days notice. It's got to specify a date that is during a periodic. So your fixed-term agreement might end on the 1st of December. You can give that notice, say, for example, beginning of November or even earlier, as long as the date when you move in is on or after the fixed term is finished. Now, there are also circumstances now where you can give a reduced notice of 14 days regardless of the fixed term. So that might be if you need to access crisis accommodation, if you need personal care and support, which has got a legal definition to it, or if you get an offer for public or community housing. So that's kind of good news. You might be on the waiting list for 2 or 3 years, and then you just signed a lease and then go, crap, I just got my offer. Good news is that you provide the information saying, look, I just got an offer. Here's my 14 days, see you later, and you shouldn't be liable for any what we call lease breaking costs, which is, you leaving earlier than, when you promised to stay. Similarly, if the landlord's selling, they need to give you this notice of intention to sell. Once you've given that, unless they told you at the beginning of the property, hey, we're selling this property, before you sign, then you can actually give it 14 days and you're not trapped into a fixed term or having people come through open inspections for the rest of, the 4 months because they're asking for too much money. Now, bonds, just touching on bonds, all bonds in Victoria have to be lodged with what's called the RTBA, the Residential Tenancy Bond Authority. That generates huge amounts of money. I think there's something in the vicinity of about $1.2, $1.3 billion worth of tenant bond money sitting there. Landlords don't pay bonds, and that could be generating another $1.3 billion to help out the housing market, but we're not quite there yet. Although land tax is certainly not a fun thing for them. So the long and short of it is that when the bond's lodged, it means that a rental provider or a real estate agent can never just say, oh, there's a mark on the wall, I'm going to take that out of your bond. They can't touch your bond unless you give consent or unless VCAT gives them permission. And if they go through VCAT, the landlord has to prove their claim. Now, the other change that happened is that renters can now, once they've given the keys back, you can just go, you know what, I'm just going to ask for my bond back. I don't want to fluff around with this. You go to the RTBA, you fill in the form saying, I want my bond back. It starts a running clock. There's literally like a, that 48-hour show. The clock starts clicking. And if it gets to the 14-day and the landlord hasn't applied to VCAT for the bond, it will automatically be released as requested. So that puts pressure on landlords to get in there. There's also a framework now of exit condition reports. A renter's got to be given a reasonable opportunity to attend the exit condition report. And so, you might go there. It's a great opportunity as a practical thing. Make sure whenever you move in and move out to take photos. That's the thing that's really going to protect your bond. Any bond claim, if the renter knows there's going to be a bund fight, they can apply directly to VCAT, and that's a free claim. Applications for compensation, so both renters and landlords can claim amounts above and beyond the bond, any amount, and they've got up to 6 years from the date of fault to bring that claim. So that's certainly helpful. So a lot of people, if you've lived with mold for the last 3 years, it feels safe to claim while you're there. You move out, you can make a massive claim after you've moved out to say, I told you about the mold, you didn't fix it, and I had to put up with all this not being able to use the property. You can't get personal injuries compensation through it. There was a High Court case from the Northern Territory, which I believe will apply down here, for distress. The First Nations woman up in Northern Territory didn't have a door for months. And the court acknowledged and says, yeah, you may not have lost anything as such, but that's pretty distressing, not having a door, no security, which leads to the point of family violence. We have a family violence kit. If you've never seen this on our website, absolutely check it out. It goes through the main thing for family violence victim survivors is that they either want to stay or they want to go. A lot of people want to go, but the affordability is a major issue. We've in fact seen there's a special VCAT application for family violence victim survivors, so they don't inadvertently disclose their address. To use. Joe is a family violence worker at VCAT. There's a family violence dedicated worker to support people through it. There's also a Koori liaison team as well. So if your client is First Nations and would really benefit from that support, Oakley is also a culturally adopted forum to make it more culturally sensitive for people, and that's really important acknowledgement as well. You don't need an intervention order. It is helpful. It's extremely helpful. With the stay or go application, it's not called a stay or go, but that's what I'm calling it. They actually have to hear it within 3 days of you applying. It's an incredibly quick turnaround. And pretty much if you've got any situation of family violence, I recommend using this process. The reason I recommend doing it is because it allows the tribunal to have the ability to adjust things like outstanding rent arrears, outstanding utility costs, and any damage done to the property. If you don't do it, it can be much harder. In particular, there's no power other than in this process to deal with rent arrears that may have been caused by the family violence. So absolutely, if you haven't checked out that kit, check it out. And if you've got questions, absolutely give us a call. Now, there's this weird thing that happened in the Constitution. You might hear some renters going, I've been told I've got to go to the magistrate's court. It's a true thing. It is literally out of the Constitution, Section 75, and between the Judiciary Act, saying that if there's another person that's residing interstate, so it doesn't apply to the Northern Territory and the ACT, then you've got to go off to off to the magistrate court. VCAT don't have the power to deal with it. It doesn't apply to companies. It doesn't apply to social housing. So any of that sort of stuff, it's not going to be an issue. But if your landlord's down here and your renter shoots off to South Australia and then applies, they won't have power. It is based on the time of when the application goes in. Again, long and short, if you hear some weird thing about magistrate court, give us a buzz. We can try and talk through. There are trained registers, but even the magistrates don't see lots of them, and that can be quite a difficult thing for people to work out what's going on. All right, rent increases. You got to get a 60-day notice. It's got to be in the prescribed form, which means that they've got to use the actual proper form. And that's really important because at the end of the form, it says, do you want to challenge this? Get this with rent increases. If you don't challenge it, it's effective. There is no cap. No cap. So if my rent goes from $1,000 up to $9,000 and I do nothing, it will be $9,000. So it's a terrible burden for renters to have to bear in terms of going, oh, what do I do? At the bottom of the form, it says, do you want to challenge it? You should say yes. And the process is you get a free report from Consumer Affairs to say whether or not they think the property is worth that much. So they literally come to the property and you go, hey, here's a moldy bathroom, here's this. Show everything you can that's wrong that would detract from the market value. Even if the report says it's not excessive, the renter can still challenge. They can still bring their own data. But it's really important that the notice of rent increase must specify the method. And we've seen that VCAT has said that, CPI, yes, State revenue index, yes, but fixed price, no. And if you just chuck a couple of other ads in there and go, here's some other ads to say that this is how much it went for, that's not really getting enough information. So if they just say, oh, we've just chosen to go here to here, here's a couple of ads, that might not cut the mustard. And the effect of an invalid rent increase is you might be able to get that money back. So anything if you above, so it goes from 500 up to 800 and you pay 800 for 2 years, you should be able to get that money back. There's some controversial VCAT decisions about, whether or not there's mitigating and should have picked it up earlier, but I don't agree with that, and we'll see how that goes in the Supreme Court when it gets there. All right, that's where appeals go from VCAT. $70 to get to VCAT, or a fee waiver if your client's there. Supreme Court, lots and lots of money. So, just be mindful. All right, practical tips. Don't pay in cash. There's heaps of scams kicking around. Take photos whenever you move in and out and back them up. My kids have dropped this phone in the toilet. Well, not this phone, many phones in the toilet many times. So just be mindful of it. Don't refuse to pay your rent. If someone's having repair issues, you can apply for the RSA, which is not the responsible service of alcohol, which is a useful skill. It is the rent special account. And so you can actually pay your money to Consumer Affairs, but you need VCAT's permission to do it. And that way the landlord doesn't get any money until they do it. So it's really important that people know their rights. So first thing, find out what your rights are. Second thing, try and negotiate an outcome, because that's what most people want to do. Most people don't want to go to VCAT. And then if you don't have any choice, you can force them, over the barrel. VCAT cost you $70. Whether you win or lose, there's no consequence other than the issue that you're dealing with. So if you lose, okay, whoop-de-doo, no one cares. They can't be blacklisted for anything like that. There's only very limited circumstances where you can be put on a tenancy database like rent arrears or, serious damage, danger notices, those sort of things. So VCAT is really the biggest challenge for people, is that they're scared to go, they're scared of retaliation. Written references are unregulated, which is a major problem. Interpreters, so you can always get an interpreter, it's free. And we know that there are some cultures where going into the city is confronting, going there. I've been to courts before, I feel criminalized. There's a whole bunch of baggage, legitimate baggage that we need to try and unpack and understand to get our clients to feel safe and even confident to get there. So that's just a bit about VCAT. There's lots of multilingual resources. If you've never been to a hearing, I'd encourage you to go and sit in the back of one so you can actually have some personal clients. This is just a simple example of a repairs application, Section 73, and you want to show your story. So this is what happened, and you have as many documents. If you're on the phone, you just get printouts or, get Adobe Acrobat and just go page A, big red letter B, photo C, just so you can refer to everything. So if you need help for social housing and public housing, Tenancy Plus program down here. And if you're in private housing, it's the Tenancy Advocacy and Assistance program. So that's funded by CAV. We are the sort of like a peak body in that network. And so if you contact us, we might be able to refer you out to the appropriate network as well and just sort of help broker some advice. Many community legal centres will still pick up tenancy issues, tripping my words, and also legal aid helplines. So there are a number of resources, but heaps of people are needing help. Sometimes you're not always going to get representation, but there's no harm in asking. You can always ask, and that's why jumping on the org line, just going, I've got a client like this. What are your chances of helping? If we can't help, what can we do? We also now have a repair toolkit that can help generate forms. So people might want to just generate a letter to say, hey, my oven's broken. If you don't fix it, this is, what I'm aware of, or help me fill in the applications, to getting the repairs done. So that's a really great tool for you to have a play around and for your clients. We know that repairs are a massive issue. Mold is a massive health issue. So absolutely check it out. We've got our contact details here. So as I said, worker support line, absolutely try and get onto that as much as possible. For the renters, there is an advice line, but just be aware there can be a bit of a wait. So, chuck your ear pods in and do some gardening or work or whatever it is that you're doing, because there can be a bit of a wait. But most people are very, very happy when they get through. But we really want to work with people because it's much more efficient to equip the whole sector, because housing is just essential, which is probably why you guys are here. I will stop sharing my slides. Sorry for rushing through that information so quickly and being a little bit over time, but I'm happy to take any questions that the crew may have, Deb.
Thanks so much, Ben. And it was such a comprehensive presentation. You should never apologise for sharing your expertise. We're actually very, very grateful to you. So, I have heard variations of this presentation before. I feel like we've all been living and breathing the new laws, the new regulations for for quite some time, but every time I learn something new, because as we said at the outset, more than 130 changes to the Act, then all the detail that kind of sits in regulation, in practice guidance, etc. So it is a busy, complex space, and it is a dynamic market, and it is ever changing, and we've got more changes afoot, as you said, with kind of new measures promised through the housing statement, but plenty of other work that we want to see kind of happen in terms of closing up kind of loopholes, really strengthening renters' rights, etc. Please, colleagues, use that Q&A box to, just make the most of Ben's expertise. Ask any question that you want. Every question is kind of welcome. We're in a kind of active learning space here, so please put your questions in the chat. There's already a few in there that I'll go to in a moment. I've also got some questions, I guess, based on like feedback that we've kind of been building over time when we're interacting with colleagues as well. I might just kind of mention there are a number of helpful links in the Zoom chat for your reference. A few people have asked questions such as information, Ben, about the particular phone number that community sector workers can use as distinct from the renter-facing telephone service. So that information's been put in the chat. We've also had some questions about whether Ben's presentation will be shared, the slides. Absolutely, and there'll also be a recording of this session that we put on the VCOSS website, and we'll send a link to that when that is published, because I know sometimes it's really helpful to kind of listen and then take another look and kind of really process and consolidate the information. So just look out for those links in the chat there that have already answered some of your questions about resources. We'll follow up post-event as well. So just to start off with, Ben, you did kind of mention a few times during your presentation, I guess, this kind of paradigm or kind of paradox where, it's one thing to have rights, and, when these laws were introduced and regulations were introduced at a particular time in the market, they were nation leading reforms at the time. There's always kind of more to kind of stretch into, but I guess it's one thing to have rights, and it's another thing to be confident to assert those. We've had a few questions about retaliatory action. You mentioned that at times in your presentation, and I know that when VCOSS surveyed community sector workers last year, one of the things that we did hear is that renters are not raising issues with their rental provider because they're really scared of that retribution, even in instances where there's like urgent repairs required and there's actually really very material kind of safety concerns. And to that end, one of the questions that we've had in the chat is, many renters are worried about being blacklisted by real estate agents if they take complaints to VCAT or try to assert their rights. Is there any reassurance we can give people about this, or any kind of like pro tips, Ben, around that?
Yeah, look, absolutely. So tenancy database listings can only occur in very limited circumstances. So a lot of them, the agencies are quite large operators like Ticker, Veta, I think they've rebranded and stuff, but they need to usually get an order, and it usually needs to be in relation to particular notices like damage or rent arrears. So if you go and have a bun fight over your bond or something, you can never be listed for that. There's an interesting idea about the tenancy database definition, because it includes any record or compilation of, opinions about a person. Doesn't even mean they have to be accurate, but we've never really had attack at the tenancy database definition. The problem, like fundamentally, is that agents talk to each other. So if they find out where you lived, and that's the reference issue, like the idea of if I don't have a positive reference, then I'm disarmed going into a market with the way the market is. So there's certainly protections around them asking about legal disputes. There's certainly protections around the actual formal listing. So when you go to apply for a property, they have to say, when we take applicants, we usually use Ticker or we usually use Veta for our checks. And then if anything comes up, they have to tell you. Listings on the tenancy database only last for 3 years. But I think one of the major reform targets is this idea of references. I mean, my blue sky thinking one day would be going, well, if we recognize this as an essential service, as long as you can pay the rent and you're not on a tenancy database, it should be pretty much like, bingo down at the local Hall of Legs 11, guess what? You get the house, Really? Like, do we have to have a competitive, I'm better than you, like it's like getting a job? It's a house. So, there's definitely a reform work to recognize this idea of prejudice. And again, from an intelligent perspective, I would think the cost of not housing people, the cost and the knock-on effect of, having this market where you're prejudicing certain demographics that are going to have more complex needs that arise from it. So there's not a perfect answer. I'll be quite blunt in that there's not, but at least we can understand that issue and understand what protections currently exist and whether or not they are working or why they are not working. So one of the examples might be that the protections about asking the questions is about asking you the question. It doesn't necessarily stop one agent going and talking to the other agent about it, like in terms of just going, oh, they lived with you, how were they? Yeah. Yeah.
And just on that you mentioning references, I think one of the things that we heard, again, with this kind of rental survey that we did late last year that we'll publish publicly shortly, is that, you know, we had feedback from organisations, from workers who are doing a lot of work supporting young people. So young people experiencing homelessness, young people at risk of homelessness. They're supporting to kind of get a foothold in the private rental market, like kind of share house arrangement and that kind of thing. And one of the barriers that they were saying that young people are facing is that they don't necessarily have any references at all
Yeah.
in terms of
Your
not
first
having
time renting,
prior rental
getting your first
history.
job. You've got to have 5 years post-admission experience, but no one's got
Yeah.
it.
And
Yeah.
so with that, I guess it is thinking about how we kind of influence, you know, the next set of kind of reforms. And I think you presented some really great ideas there. I mean, Ben, is that something that you've got any advice on in terms of just the here and now circumstances? Like, how do we help kind of people overcome that issue if they don't have any references at all? So we're not even talking about bad, you know, a bad track record or bad references, but no references at all.
Look, I think with no references, part of it is this, and we're seeing this movement both at both ends of life with the young people and with older persons. A lot of old persons where the pension's just not cutting it anymore are returning to share houses. And so if you've been on a lease, like you've been joined, because the law says that they can't unreasonably withhold consent about you joining, you've got to be really careful when you join, because when you join, you're jointly liable. So if, you know, Deb and I are on the lease and Deb's been there, and actually I've been there for a long time. I punch holes in the wall, and then Deb takes over my tenancy or joins with me. At the end of the tenancy, if there's $3,000, the $3,000 can be taken entirely from Deb or Ben, not, you know, 50-50 split, or not just because Ben did it. So definitely you want to be careful about who you join, but share housing really is one of the options a lot of people are turning to. I might just jump on one of the questions I saw as well. Jeanette says, why don't Tenants Victoria help people in apartment buildings? We do. I'm pretty sure we do. We wouldn't help people that are in an owner's corporation or a strata owner, like people that own it. But if you're a tenant and you live in an apartment building, absolutely we would. And I got picked up by Mona for using the term financial advisors. They're completely different. That's when you want to go and make lots of money and get charged lots of money. Financial counselors are the best crew, awesome, and they're about helping you manage money and get advice, get counselling. My apologies. I'll get that right one day. Yep.
Thank you. Thank you, Ben. Just turning to some of the questions in the chat. One of the first questions that came through as well is around noise disturbances, Ben. And why do noise disturbances complaints only apply after 11 p.m. when noise complaints can happen anytime, especially apartment living?
It's not strictly true. Noise complaints can happen at any time. I think it's section 48A, somewhere around there of the Environment and Planning Act, which talks about local council bylaws about nuisance. So the idea of the emission, the frequency of when it comes, where it's emanating from. So with a landlord, one of the issues that we have is, you know, thin walls between buildings, and we don't really have a sound minimum structure. It talks about being, you know, weatherproof and structurally sound, but we don't have any sound tolerance. And sound complaints are very hard to resolve, to deal with, and to look at practical adjustments. So the modification framework might be some relief, but those noise complaints, the 11 p.m. really just probably comes from council saying, well, that's the rule. They can't have loud music after 11 p.m. But if they're blaring it like 24/7 the rest of the day, then you're looking at this idea of nuisance. And the real problem is that for people that don't have lots of money to go off to the magistrate court and going, I'm having a civil dispute on the tort of nuisance with you, it becomes hard to press it. So there are real gaps for, you know, I mean, I still don't know after 20 years of practice whether it's illegal to steal a loaf of bread when you're starving. I wish I did, but I'm going to say it's okay, but I don't think it is. So, you know, yeah.
Thank you. Thanks, Ben. Another question that's come through is, Ben, someone's remarked that there are a few times during the presentation when you touched on the fact there are different rules or parameters for residents in social and public housing. And the person is asking, how can we find out more about their rights specifically?
Yeah, sure. Great question. So the long shot is this. 95% of the time, the laws that apply to a private rental provider will apply to the Director of Housing or Social Housing. So even though the Director of Housing has got this repair hotline and all that sort of stuff, you just go, I told you about it, sent an email, you didn't respond, I'm straight off to VCAT. We see a lot of people waiting on that sort of advice line stuff. And the same thing, it's beneficial for renters to actually have the written notice, because if you call on the advice line, VCAT will go, prove to me that you reported it. And you're like, oh, I can't because it's on the advice line. So the only real differences in sense are often the policies. So there's a whole backlog of policies, which is about certain things that VCAT actually generally can't deal with, like the rental rebate, about whether the rebate's cancelled or not. Although that's become a little bit intermixed with rent arrears, because they're like, well, we can't decide how much you owe unless the rebate's settled. And so often you might appeal the rebate assessment, like in terms of whether the rebate should have been given or not, to decide whether there's rent arrears, because VCAT needs that to decide if they've got power to kick you out or say, yes, you definitely owed 14 days. So starting point, I think, would actually be to look at the Director of Housing policies. Community housing policies are not consistent and they're quite different, and there are big differences. So if I go into jail for like 4 or 5 months, I can get a temporary absence of leave, pay $15 a week, keep my tenancy. In some community housing agencies, I go in jail, I fall in rent arrears, I get kicked out. So we need to be very careful with that when people are on the housing register waiting list, that they understand that they're getting quite a different product in terms of the protections, accountabilities. There is, when you want to complain about housing, community housing, it goes to the housing registrar, which is different from the housing register waiting list, complaint body. But above that, if you're not satisfied with the outcome, you can actually still go to the state ombudsman. So Deborah Glass, I think, is finishing or finished up, but the state ombudsman has expressed a real interest in this space because it's such an important issue. So yeah, great question.
And it's also worth mentioning, as we said a few times before, this is a really busy and complex reform space, and lots of kind of intersecting reforms, lots of pieces of the puzzle. And I know many people on this call, and you'll have colleagues who are not on the call today, but that were actively engaged with a review that took place a few years ago with David Haywood, Heather Holst, David Cousins, engaged by the state government last term to have a look at rights in social housing, so both public housing and community housing. And a big kind of theme coming out of that, social housing regulation review was looking at kind of the differences in kind of people's rights in those different types of housing that all come under the umbrella of social housing, and this, real kind of desire to harmonise the rights between people in public housing and community housing with a view to lifting up. So not kind of a reductionist approach. And that work has not been kind of like the final stage of that work, not publicly released, and something that many of us, including VCOSS, are continuing to encourage government to release the final report. The work we believe that we know was excellent and thorough, including a lot of kind of consultation with people living in public housing and in community housing, as well as people working in support organisations, working in provider organisations, etc. So we're really kind of keen to see that work progress. So worth kind of mentioning that. But in the meantime, Ben's given you a good steer on like where to kind of familiarise yourself, or how to familiarise yourself with the current suite of rights.
And when in doubt, call us.
Yeah. Thank you, Ben. Always so generous. Another question that's come through is, does a rental applicant have to disclose whether or not they will be residing in a property with their children?
Look, it's a really interesting question. I would think not. So when you rent a property, it's called exclusive possession. So, I might not have my kids with me now, but I can bring them in later. My grandma might want to come and live with me, so I can have whoever lives with me as long as I retain that idea of exclusive possession. And so there's often a tension with some of those households between what's called a licensee, which is not protected by the Residential Tenancy Act, and the renter. And we see that with some of the subletting arrangements, with couch surfing. So in the housing market, the way it is, there is quite a lot of exploitation, and a lot of people will go, I don't know what my rights are because I kind of just live in the house. And again, that's a really good one for people to just go, well, I don't know. I can either go to VCAT and find out and just go, I don't know what my rights are. Can you tell me, sort of thing? We've got a legitimate dispute, or otherwise, again, you can give us a call. But it's really important because people that are insecure often won't reach out, and that makes them vulnerable for all sorts of types of exploitation.
Yeah, thank you. I think one of the things that's really interesting around the RTA reforms, Residential Tenancies Act reforms as well, is around like what kind of housing is in scope and what's not. So you mentioned during your presentation, for example, that specialist disability accommodation was previously sitting under the Disability Act. That's kind of been moved into the RTA now, if I'm representing that correctly. Ben, and crisis accommodation, there's kind of references to crisis accommodation, like in the scope of the RTA
Well, crisis
as
accommodation
well?
is really interesting. So that's very clearly cut out of the Act. And in fact, there used to be a 14-day time limit. They've got rid of the time limit entirely. And so that means, but the important criteria of identifying an exempt crisis accommodation is it's got to be funded by Director of Housing or Director, I think, of Family Violence and Services or Minister for Services. So in that sense, it's actually quite limited. So some people may call themselves like a shelter or something like that, and they say they're temporary crisis accommodation, but they actually may not meet the legal definition. I had one of these the other day, and that in fact may mean that they are protected by the Residential Tenancy Act when the provider trying to do that. Because the reality is, with the no reason notice to vacate gone, a lot of that ability to just move people on or leverage them out, saying take the offer or other, we've got to provide for someone else, has gone. And so there is a bit of tension around exactly working with that. A lot of temporary crisis accommodations say that they're able to rehouse a good proportion of people, but that churn and again the backlog, even in transitional housing, we're all looking and going, well, a lot of the time you can't be put on a list until you've got your possession order saying yes, you're about to become homeless, and that's a really big tension of just there's no movement in the system with the vacancy rate the way it is. Yeah.
And just on transitional housing, and I'm not sure whether this is kind of like in scope for you,
Yep.
Ben, and if not, we'll look at where we kind of place the question and how we kind of get the answer to this. So I've got a couple of questions around transitional housing. So let's see whether they're kind of, things that you can able to kind of engage with right now. But so one of the questions is, what happens if someone is in transitional housing, begins working, and then is no longer eligible for social housing?
Yeah, this one's a little bit tricky. It is within scope because it's in the Act. There's a notice to vacate where they can give it for not meeting eligibility criteria. But the interesting aspect of that particular notice is that I don't believe they've ever gazetted the eligibility criteria for this. So that's one of the reasons we don't see this notice very often. So in that sense, usually the regulator is that they force it up to market rent. So you say, well, you lose your rebate and then you pay market rent. So if you're living, on your rebate from bottom up, 25% of your income in Collingwood in a 3-bedroom house, and then you go to market, you're like, oh, geez, I don't think I'm going to be able to afford that anymore. And so that tends to be the driver of how those issues are resolved, more than the actual, we've formally assessed you. We have seen the introduction of an affordability scheme where there is a similar idea of, give us your financial documents. If you don't meet this criteria, that can apply. But generally for public housing, community housing, that tends not to be the issue as much. It tends to be driven by the rebate as the de facto forcing people in or out. Yeah.
Yeah, fantastic. Thank you. Another question. So this is, I guess, moving beyond the current scope of the current laws, and we will flick back to the current laws in a minute. But there is a question about, is there any proposed time frame around the transferable bond scheme?
We know nothing. We know nothing. The housing announcement was made, and I think, to be honest, the government's probably going to grapple a little bit about how that carryover works. Currently, there is a bond loan assist program where a lot of people that probably don't know they're eligible could be eligible for that. That's a slightly different thing where you're getting money from Director of Housing. If you lose any money, you pay it back and you can get another one. This is the idea of carryover, and I find it hard to think that you're not going to actually just transfer the money held by the RTBA in a different name and then have to top up your bond, but we really have no idea about how that will actually work.
Yeah. And I guess on that, Ben, I think important piece of context as well is that this is where like the role of Tenants Victoria as, not only, a CLC, a support service to tenants, but also the fact that you are, a peak body and advocacy organisation as well, is that, your voice is really important in terms of like working behind the scenes as well as through public engagement processes to really kind of try and inform the detailed design of some of these kind of measures that sit, for example, in the housing statement. There's a really important role for VCOSS and other peak bodies, other housing peaks as well to play. And really it's about kind of lifting up your voices to the people on this call in terms of helping kind of, extract the best knowledge out of this sector so that, government can design best possible, in this instance, portable bond scheme, etc. But that also kind of equally applies to other measures that have been kind of committed to through the housing statement, such as, this establishment of a new dispute resolution body as well that will play a different function in the ecosystem to VCAT.
Yeah, that's a really big unknown as well. So we don't know what things will fall. So So by way of background, the idea is going, well, VCAT, particularly during the pandemic, has been so backlogged with all of these claims. They want to invent something that's, a different resolution process, and we're concerned about, is there going to be duplication? Is it going to be more efficient? Is it going to be more accessible for renters? And which type of issues will go where, and to make sure that doesn't cause more confusion for people too. Because it'd be great to just go, hey, here's a photo, my oven's not working, call up someone, they go, all right, landlord, we've got a report, we're satisfied the oven's not working, fix it by date. Wouldn't that be great?
Yeah,
So just to
exactly.
overcome some of that retaliation and just the complexity or the fear of, again, going to VCAT a bit.
Yeah. Great, thank you. Another question is, can disputes between people on the lease be taken or resolved by VCAT? And is also that the
Tricky.
ideal pathway, Ben, as well? So what's your advice on that? So I think there's a transactional kind of like answer here around yes or no, can disputes between people on the lease be resolved by VCAT, but also, is that something that you would recommend? Like, what other steps could we think about?
I think Kate's nailed that one on the head. It's a gap. It's a big gap. There are spaces and circumstances where you might find exceptions. So a number of years ago, we had one client, two people on a tenancy, one goes away on holiday, the other one burns the house down. And so under the Wrongs Act, you can say they burnt the house down. It really should be on them. Complicated argument, successful. But it is generally something that VCAT will run a million miles away. So if you didn't pay your bills, or I paid rent for this month and you didn't pay that rent, they usually won't touch it on the basis of that joint liability. The exceptions will be around family violence, but also personal violence. So some of that framework about apportioning liability can be entertained in the case of personal violence. It's where people are not necessarily family members, but you do need a personal violence intervention order. Family violence is a little bit different, where you don't need the intervention order. And it's important to note that family violence is a pretty broad definition about people that you treat like family as well. So if you've been traveling around as housemates for the last 20 years, pretty close to family. So there is a bit of flex in that definition, but I think, for average housemates and punters where they have that sort of, bun fight, a common issue that often happens is that one renter will just shoot through. They'll go back and live with mum and dad, go, I can't afford it, and you're on your own. But the reality is that when one person leaves, you're still jointly liable. So unless VCAT releases you, or the landlord, for some magical reasons lets you off and says, yeah, I won't go after you, you're actually still both on that lease. And if it falls over for rent arrears, they're both on the tenancy database, or the other person keeps on paying the rent to keep it going, but it's not living there. So it's a pretty yuck tension, and people do find it hard to get advice around that sort of stuff. They do have legal rights against each other, but it's probably a magistrate private civil dispute, which is not a very usable place.
Yeah, great. Thank you for stepping us through that. You mentioned family violence, and just questions coming from a different kind of angle in relation to family violence, and might just kind of run through those.
Yeah, sure.
One of the questions is where consent for family violence safety modifications has been requested, but the rental provider has not responded after repeated requests. What are the tenant's options?
Pretty much once you've asked them, if you set a time limit saying, look, I need a response in 24 hours or just immediately, or you just think, look, I've put my request in and this is not going to go anywhere, you can apply to VCAT. You just apply under Section 64. VCAT has to list it within 5 days. And to be honest, like, really, given the nature of family violence, if you need to do something to improve the property, like, it's not ethically great to advise this, but just get the property safe and then say sorry and work it out later. Because the reality, like, VCAT is never happy to go, I'm going to retrospectively say it's okay, but they'll be like, oh, you breached, but you're not going to kick that reasonable and proportionate test. Yeah, I'm going to evict you because you tried to protect yourself from someone trying to come after and kill you. No, it's not going to happen. So we just want to be really practical. We see people will be a little bit cagey with changing keys. It is really important to have an intervention or a safety notice on the point of changing keys, because technically the agent, if both parties are still on the lease and there's no document like that, they should give both parties a key. You might get a great agent that goes, yeah, I know what you're on about. No, but that's a risk for the agent. So that's why the IVO from a pragmatic point of view is really important. Changing locks, even if it's a master key system, can be done. But yeah, CCTV is really important, and same with teaching victim survivors with using their phones to record any evidence, is that the police, when you've got an intervention order, it's not criminal in nature, but breaching an intervention order is criminal, and the police, in order to charge for a criminal offence, have to prove beyond reasonable doubt, which is a much higher threshold. So a lot of threats to kill, if I'm going to fucking kill you, sorry for language, but that's sort of how it goes. Is going to be something you want the audio for. And if the police don't have that audio, they're like, we don't have enough evidence to charge him. So, we really want to make sure that we're a little bit vigilant about getting that evidence, but obviously only do it when it's safe to do. So talk to your Marin people, talk to your family violence specialists, but that's a cultural thing for us. And that's why having CCTV, it's very affordable. It's also really good if you ever put a CCTV system, check it so it works, because don't just shove it up and then think, oh, one day I'll need it and I'll just get it. Make sure the thing damn well works. Yeah.
Yeah, yeah. Thank you. That's really great advice. Just again on the important matter of family violence, is a question around, and we know economic abuse is a really significant issue. How does someone get half of their bond back after leaving due to family violence and taking their name off the lease?
Yeah, sure. So with taking your name off the lease, it actually ends the agreement. So if you apply under Section 91B, the process is you're saying, I want to end the agreement, and it ends it for everyone. And so that means that the bond is there. Under Section 420 capital A, people can actually say, well, I'm leaving because of the bond. I want my bond share to be protected. I want it to be released. And so they look at if there is any bond claim as to why the bond claim has been made. So it might be, I've got to leave because there's, I had to leave at short notice, family violence. I didn't get a chance to clean. Those sort of things, or there's holes in the wall from what, apparently looks like, violence. So VCAT has a discretion in that. There are a couple of good decisions because there's no legal criteria specifically spelt out in the Act, but VCAT's made it pretty clear that that is a discretionary power. They look at the cause, the detriment to the party, and they can protect that bond. So once that order's made, the bond can also be dealt with once they've gone and had an inspection and that claim's there. So again, the RTBA claim can go in there. Do need to be careful with the RTBA family violence sort of claims. Again, you follow the same process to trigger it, and don't disclose any address, and then they can deal with it pretty much in the normal way, with the exception of recognizing the family violence is there. Yep.
Thanks. Now we've got a few questions that have acronyms in them, and we've got very, system engaged, system wise, people on this call. But I think, we're always really focused at VCOSS at not making assumptions that everyone's kind of like across all the acronyms. And, after years of working in this space, sometimes I forget what some of these acronyms are. You mentioned earlier in your presentation, you used the acronym RSA, and you made clear that you were talking about responsible service of alcohol. Can you just, before I ask this next question, can you remind people on the call, what does RSA stand for, Ben?
So it's the rent special account. So the rent special account is your ability to say, and you can put this on any repairs application, urgent or non-urgent, and just pretty much say Section 73, urgent repairs, Section 77, I want to use a rent special account. And you can do that on first instance. This has been around for a long time, but the laws have changed where it's not fully mandatory, but it's much more compelling that if it's asked for, it should be given, unless the landlord's in massive financial distress. I can't pay my school fees or whatever. So that's there. And one of the other things as well, it's been an ancillary feature to a lot of non-compliance with the Act, is also there's a landlord naughty list now. It's called the Residential Rental Non-Compliance Register, which sadly, after almost 3 years, and the listings last for 3 years, there's only about 17 people on it. Which which brings me to the other point. Sorry, really, really excited.
So say Purple Pingers has a higher number of.
I was just going to say, I think as a result of some of the great work of many advocates, including some people, that the government's announced a task force. So a task force to look at it. So there was this massive underquoting thing going on for when people are selling, and now they've actually gone and looking at infringements, because there's very few infringements historically that have been issued by Consumer Affairs. Easy activity to do, but they're not doing it. Whereas now they've got this task force, which is backed by $4 million and whatever else the media announcement is. But so I'd encourage you, if you see non-compliance with minimum standards, which is an offence, or any other offences under the Act, like not lodging a bond, dob into CAV, because we want to give them as much fodder to go, make this a real law, make it enforceable, make there a little bit of fear in the sector, go do the right thing. Anyway,
that's right. And just a reminder, CAV, Consumer Affairs Victoria.
Yes, thank you.
Sometimes referred, we also sometimes like just use, we just say it as CAV, for example. But just going back to the RSA, there's a question about regarding the option to make payments to an RSA to encourage landlords to do repairs. The person's asking, is this like after a VCAT hearing that a landlord has ignored? So like at what point does...
Look, you can ask for it. You can ask for it at any point. They're certainly more likely when you get that non-compliance with an initial order, or they demonstrate a real recalcitrance or a reluctance to go, now stuff you, I'm not going to do whatever you tell me, or maybe even they don't turn up. So it is discretionary still, but I think this is again where looking at the specific law, it's under Section 77 of just going the tribunal must do this unless, and so the default position is that it should be accessible for renters. Some people it can be inconvenient in terms of just paying your money money somewhere else. You know, you might have centre pay lined up and it becomes a little bit complicated, but it is a useful tool, and we certainly don't encourage people to not pay their rent. But again, the main thing that we look at is that compensation claims are, you know, money talks, and you can actually make a comp claim against some of the money held by the rent special account. It is also possible, it's a little bit sort of more technical, but it is also possible to get a rent reduction. So one of the things with the renewals, like if they say fix your oven and they don't fix your oven, you just write back to VCAT and say, hey, they still don't fix the oven. You go back and you say, I want, you know, $30 or $50 a day off my rent, which would probably be pretty high, you know, because the oven's not fixed. And they'll go, yep, that seems reasonable. So, you know, you only have to pay lesser rent for that period. So it's another way of doing it. It's really just about, again, getting them to do the right thing. If they're really difficult, you can actually take an order from VCAT and register it in the Supreme Court and take it to the Supreme Court for cost, but you really want to be sure you do that. It doesn't happen very often, Section 122 of the VCAT Act, just if you want to scare them.
Now, thank you, Ben. And this session has just gone so quickly, so I'm conscious of time. We'll wrap up the questions shortly, but there's still so much to talk about. This is an incredible kind of, you know, opportunity to kind of, you know, basically be on your brain, Ben, and understand everything that's going on. One of the other questions, that this has also got an acronym in it, EOA.
Yep, Equal Opportunity Act, I believe.
Yes.
Yep.
So what are the practical implications of the Equal Opportunity Act now being incorporated in the RTA?
Yeah, look, it is a great question. I think the first point is that it creates a global awareness. So whenever you apply for a rental property now, they have to actually give you a full statement of this is what discrimination is, these are what are protected attributes, and it gives you an outline, which is really important, that it doesn't matter whether you intended to discriminate or not. It doesn't matter whether you knew it was discrimination. It doesn't even matter if it was the dominant purpose. If it was discrimination, you know, looks like a duck, smells like a duck, and it's a duck, you can actually make a claim for compensation. So you can make a claim for comp under Section 210 AA, I think it is, or you could do it under the Equal Opportunity Act. Either way, what it does is that it gives someone a much stronger position to say that you've engaged in discrimination. Like I was on the radio a while ago, and a guy just went, "Oh yeah, they found out we're a gay couple, and they chose not to give us a property because of it." And it was just on radio. It was kind of casually mentioning it, and sort of the tolerance of this has been my experience of life, and just going, and I'm just like, this is outrageous. Like, how blunt can you be? You know, so what is sad but understandable is that we still don't have many decisions around that. And so it gives us the opportunity for the champions within the community to take them to task, to make an example of them, to say that discrimination is not acceptable. We know there's discrimination, and that's why we're doing the research project, which I should probably pop in the chat somewhere.
Yes.
Yeah, so definitely it's a good starting point. We have a while to go, but it is an opportunity. It's the beginning of a story. All doctrines of law come from a case, whether it's a snail in someone's beer glass or someone not washing their undies, which is a very funny case. The doctor got, I think, about £2,000, which would probably be about 40 grand for undies that he didn't wash for 12 weeks, but the sulfide compounds made him itchy and he got some money out of it. So, you know, everything starts somewhere. So we're hoping there's champions out there in the community that recognize discrimination and, you know, take the action that will help many other people.
Yeah, great. I'm going to move through some other quick questions as quickly as we can, but there's so much, like, as I said, to talk about. One of the questions is, this relates to children again. It's very specific, so it's not an identifiable family, so we're not breaching anyone's privacy, but it is specific in terms of some of the dynamics of this. So the setup is if a couple is renting a one-bedroom apartment and they have a baby or a small child with them, would they need to disclose this in their application, given the property only has one bedroom?
No.
Can real estate agents legally say the property is unsuitable in that case due to the number of rooms?
Well, this kind of goes back a little bit to the discrimination issue. I mean, I co-slept with all of our kids. So one bedroom, I've got one partner, and I co-slept with the kids. The issue which a lot of parents, which is a real issue as they get older, is around that issue of suitability for the children. So we see that in public housing. There's, you know, appropriateness of ratios of rooms, and so this is broadly speaking the issue of overcrowding. And so again, we know that there's a housing crisis. Like, if child protection are alerted, if you're good parents and it's going on, well, you know, it's the best you can do. Fear of losing your children is very real. I mean, if you've ever had child protection in your life, you know that that's just absolutely terrifying, and people will do everything they can. But in terms of disclosure obligations, again, this is a question of the children. Should they even know you've got children? What happened if I'm a couple and then we've been there for 2 years and we have the child while they're there? You know, evict me because I've got a kid? Don't think so. So, you know, I think that it needs to be viewed in context. Again, the issue is the rejection. is that, you know, if you disclose that information, you get rejected. You know, can you make the argument that that has been discrimination? Like, in the idea of going, well, that's the best we can do at the moment, you know, it's bloody cost of living. You know, so I would raise those sort of issues. You can do it in conciliation context if you want to, you know, confront someone about it, going, look, you might not have given it to us, that's not on. Or you could just go, well, I don't really care, I'm going to go and have a go at VCAT. In some cases with discrimination, or where you've got clients with really sensitive information like mental health background or otherwise, you can ask under the Open Courts Act to keep or give it an alias name. So not all decisions are published. In fact, very few are. You always have a right to ask for written reasons from the tribunal. You've got to do that during the hearing at any point. It's courteous to do it at the beginning. But the important thing, I think, is to understand that if there's information that might go into public domain, that you can request that that be kept anonymized. So it might be referred to, but it doesn't say, you know, Ben has got chronic depression and bipolar. Yeah.
Thank you, Ben. I'll just try and ask a couple more
Yeah,
questions.
sure. I can do a speed run on some of them if you want.
Yeah, that's great. This one probably maybe is like an adjacent kind of
Mm.
question to what we're talking about today, but you know, an important question from colleagues here. Is there anywhere to place a report against a housing access point organisation when they treat your client unfairly?
Yeah, absolutely. So the Director of Housing will have its own complaints body, so there's levels of complaint in it. Ultimately, once you've lodged a complaint, if you're dissatisfied with the result of that, it actually can go to the State Ombudsman. So many years ago, we had the practice where MCAT switch and maintenance claims against tenants, the tradie would come in, do like 60 grand of work, the housing officer would just pass it straight on to the renter and go, here's your 60 grand bill, and the renter's like, what the hell? A bit like the robo-debt thing, they just sort of passed it on and didn't turn their mind to whether or not the renter was at fault. And so the Ombudsman did what they call an own motion investigation. You only really need a sample of maybe 3, 4, you know, in a bigger matter, maybe 6, to show that there's something systemic going on. And the Ombudsman's like, that's obviously not just a once-off. So let's go and have a look. And that's an incredibly powerful tool to get the Ombudsman on side to go and check that out. And they're interested. They're interested in the information and the stories of your clients that you know.
Yeah, great. Another one is on community housing. What's the best option for someone who is in community housing to get repair complaints, both urgent and non-urgent, resolved quicker, when the community housing organisation is not forthcoming in resolving the issues?
It might be the lawyer and me just taking to VCAT. Like, it's the same process. So this is the idea, is that, like, it's really, in fact, if anything, people in social housing can be more robust because they're not going to get a no reason notice. It's unlikely they'll get an end of fixed term, and they've got an obligation really to house them once they're approved for the housing. So what are they going to do? They're going to go, you're a pain in the butt, let's try and get this resolved. And so it's a little bit of squeaky wheel gets the grease. Now, the reality is, I know there can be some housing officers that are amazing and beautiful and wonderful, and there are some that can get pretty vindictive. So, you know, you pick your battles, but the reality is, if you want it done quickly, get them into VCAT. There's a saying in litigation generally, and as lawyers, is that most things settle on the court, like the steps of the court. Like, you get there, you get all this big palaver up, and they go, all right, yeah, we'll do it. And then you get consent orders, or you can, you know, get an agreement. Even if you get, you know, you can do what they call orders on the papers. So people reach an agreement, you send it off to VCAT as a draft, and they say, yep, all right, we'll order that, and it's enforceable. What you want is something that's accountable, measurable, and enforceable. And if you need guidance, give us a call.
Yep, great. Another question about the RSA that was mentioned earlier. We had a few questions about that. The question is, if I request my rent to be paid into RSA, the repairs still haven't been done when my lease ends, will that rent be released to the landlord when I
Great question. That's a really good question. We have seen one VCAT decision that sort of actually left it held up, sort of pending bond and ancillary stuff. So I think that a lot of members might do it, but the requirements when the rent special account is used is they actually have to give a date. You know, this money is held until this date. So if that tenancy goes on beyond the date and the rent special account is another month on it, you can make the claim. But I think probably the more important thing is that most landlords have got assets, so they're not what we call judgment proof. So if you get an order for $2,000 and they go, stuff you, I'm not going to pay, you can go and take that, register it with the magistrate court. It will run at about 10% per year, and you can actually garnish wages. And ultimately, if they were being really difficult and the court said, yep, you're just being difficult, you can make them sell their property. I think something like that's happening to Trump at the moment, isn't it? Anyway, I'll put that out there.
Thank you. I'm going to ask 2 more questions, and there's a bigger kind of philosophical one, which kind of then ties with some of my kind of closing comments as well. Not philosophical, but kind of big existential, you know, question about like the impact of kind of the current suite of reforms. Really quick one, 2 quick ones. How do you prove the letter of notice has been given by hand?
Yep. It's usually a factual finding. So if the renter disputes that it was given, the burden of proof, the one that has to prove their case, is on the applicant. So if the landlord's going for the notice to vacate, they're going to have to prove I gave it to them by hand. And if that's disputed, the tribunal will listen to one side, listen to the other, and the threshold is the balance of probabilities, which is who's more likely to be telling the truth. I think that it was given, I think it wasn't given, and that'll be a factual finding, and then you go on to the other issues. But if they say that they accept that it wasn't given, then they have to dismiss it. Yep.
Yeah, great, thank you. Going back to noise as well, who can tenants go to concerning noise complaints with regards to other tenants in an apartment building?
That's a common one. It will actually depend a little bit on who the landlord is. So if they've each got separate landlords, it's going to be that the landlord's really in the same position as, the tenant is in the same position of the landlord about being able to resolve the noise complaint. But there is one decision called Clark and Director of Housing, which says if there's a shared landlord and and you've complained and the landlord does nothing to address that issue, there may be compensation that could be payable because an occupant of one of their other properties is doing something. So they can be a little bit messy. There is a gap in the service provision. Like, we often wouldn't advise on that, where you've got potentially two tenants, because we're trying to keep people in properties. And we see that same thing with behavioural issues, with abuse, neighbourhood disputes is a really big gap, and it has massive impacts on people's mental health. If you're living next to DV going on, how you engage that. Do you go and get your own intervention order because it's affecting the neurology of how your children are developing? It is a complex issue, and it is hard to get good advice, and it's hard to action. So there are rights, but again, it's not very accessible framework. Yeah.
Now, I'm going to set you a very big challenge, Ben, and one that I would not really want to set for myself is that we've got a really big question here,
Sure.
which is, do you get the sense that the new laws have actually filtered through to the market much, given that renters might not feel they have much power in such a hot market? So what are your kind of, in 2 minutes or less,
Sure.
what's your kind of take on that?
I think if you ask the landlords, they'd say yes, and we're leaving. But the reality is that it has no real effect on the housing stock and availability. So has it had an impact? Absolutely, it has. We've seen that some of the research has shown that there's been improvements in the housing that's being offered. I think, look, after many years of doing this, the reality is that my heart is on the supply question of going, we are helping people out, we're keeping them home, we're buying time, but the pressure, all of this anxiety about being able to have an essential service comes from supply. It comes from affordability and benchmarking. So when we talk about the rent increase framework, if I go back to that, is that there is no cap. We have no benchmark that refers to the hardship on the renter, which ironically we did in older legislation. In the old 1958 Act, there was what's going to be the impact on the renter, and we don't have that anymore. So has it had an impact? Yes. But are we impacting the right spots? We're only really just starting to look at them. That would be my view. So 130 changes, excellent. Getting rid of the no reason, cracker, great stability, but everyone needs a home.
Okay, now I'm going to talk as fast as Ben to just quickly wrap up. Please stick with us for these next few minutes. But first of all, big thank you to Ben, absolute superstar. Thank you to Ben and our colleagues at Tenants Victoria. Please check out the Tenants Victoria website. Lots of information, lots of resources. We've also got some complimentary resources on the VCOSS website on our kind of in regard to our past renters' rights rundown events. So please go online, avail yourself of those resources. Before I wrap up, just want to mention a couple of things. I've mentioned our Renting in Victoria report due to be released shortly. It's been developed with insights from you. Thank you to all the people that responded to our annual survey late last year, our poll questions at the end of our last Renters' Rights Rundown events. We do use these insights to advise government on how implementation of the reforms is being experienced in the real world, especially for low-income renters and renters experiencing other forms of hardship. You've told us too many rental properties fail to comply with minimum standards. Mold's still a common concern. You called for stronger monitoring and enforcement action by Consumer Affairs Victoria. Ben's mentioned task force has been announced last week, which we welcome. We've been, promised by the government that that's going to come with resources to employ more intelligence analysts, inspectors, investigators, lawyers. We need to be making sure that we engage with that task force so that they're really seeing what's kind of playing out in the market. Some of the other issues that you told us about, there's not enough rental homes, as Ben mentioned. Rents are way too expensive. Evictions are still confusing and too common. Family violence challenges still persist, and VCAT is hard to access and navigate. As we've mentioned, some of those issues will be tackled through new measures that the government's promised in its housing statement. we're going to make sure that we're lifting your voice in the kind of detailed design work, and we'll continue advocating on other reforms that are needed, such as growing social housing, and also, continued advocacy on other reforms, such as, tackling kind of those rent increases, such as the formula for fair rent increases. The other quick thing I wanted to mention is that on the 17th of April, there's a VCOSS member consultation on minimum energy efficiency standards in rental housing. So Ben mentioned, one of the gaps at the moment, for example, is there's nothing there around ceiling insulation, a number of other things related to energy performance. There's going to be a regulatory impact statement coming at some stage by government. We want to kind of get ahead of that and be supporting community sector voices to be strong in that conversation. So there will be a written submission from VCOSS. We're going to be running a member briefing and a consultation workshop on the 17th of April that relates to the Victorian Government's gas substitution roadmap. If you think regulatory impact statements are a little bit overwhelming, we're here to help you step through that and make sure that your voice is heard. There's a link in the Zoom chat to register for that event. It's for VCOSS, people working in VCOSS member organisations. Just as we wrap up, I want to thank the Victorian Department of Government Services, the Victorian Property Fund for supporting us to actually run this event. Thank you all for attending. Reminder also, please take a few moments to complete the event survey. It's going to pop up on your screen imminently. That will help us plan for future events like this. We'll also have a full transcript, caption video recording of this event in a few days. We'll send you a link to all those resources. We'll chase up any questions that we didn't get to today, except I think we actually got through them all. So scratch that. And please follow us and Tenants Victoria on social media. Sign up to our email alerts to learn more about events like this. Thank you, Ben. Thanks to the VCOSS team, my colleagues Deborah Pearce, my colleague Radhika Rego, and Miriam Sved as well for helping behind the scenes, and of course Ryan Shields as well, who is kind of a master behind the scenes with all of this, but particular big shout out to Deborah Pearce and Radhika Rego today as well. Thank you, Ben, absolute legend, and hope you will enjoy today's event. Thank you so much.